arbitrationagreements.org. Welcome to this introduction on the basics of employment arbitration rules. Before we get started, please give this video a thumbs up. Press the subscribe button and hit the notification bell so you can stay up to date about important alternative dispute resolution topics, which can help your customers stay happy and keep costs low when problems occur at your company. Arbitration is a form of dispute resolution that takes place outside the traditional court system. It's often used to settle disagreements between employers and employees. Here are some statistics to give you a perspective on its significance. In the past decade, there has been a 25% increase in employment-related arbitration cases. About 80% of Fortune 100 companies use arbitration clauses in their employment contracts. Now let's delve into some foundational rules for employment arbitration. First, the process typically starts with an agreement. Both parties must have previously agreed, often in the employment contract, to resolve disputes through arbitration. Next, the selection of an arbitrator is crucial. An arbitrator is a neutral third party who will hear the dispute and make a binding decision. Both parties usually have a say in choosing this individual. The proceedings in arbitration are less formal than in court. However, each party presents evidence and witnesses, much like a trial. Confidentiality is a hallmark of arbitration. Unlike court trials, which are public, arbitration proceedings and decisions are usually private. This can benefit both employers and employees by keeping sensitive information out of the public domain. Time frame is another advantage. Arbitration can often be faster than taking a case to court. It can span several months instead of years. Costs can be ideal because parties save on prolonged court fees. Lastly, decisions in arbitration are final. While there are very limited grounds for appealing an arbitrator's decision, generally, both parties are bound by the result. It's vital for both employees and employers to understand these basic rules. Knowledge of the system can help both parties navigate disputes more effectively. If you want to learn more information about arbitration, please visit arbitrationagreements.org. That is where you can purchase what you need to start the dispute resolution process in the correct fashion to handle issues online. Our association does not provide legal advice, but many people from multiple industries use our services to navigate claims in a controlled manner through a cost-effective framework. If you're interested in doing that as a business, give us a call. In fact, big companies use arbitration because it helps them control costs. You're paying one service per case instead of having uncontrolled expenses that any normal lawsuit would cost. That's the real reason people use arbitration. Also, what do you think about employment arbitration? Which advantage is your favorite? Drop a comment below and let us know your opinion. Please do not forget to give this video a thumbs up, subscribe to our channel, and hit the notification bell so you can receive the latest updates about dispute resolution that can help your business succeed.